From the News Channel 5 Network, this is Inside Politics.
Hello, everyone. I'm News Channel 5's political analyst, Pat Nolan. Welcome to Inside Politics. The first Monday in October is always an important day in our nation's government and politics. In 2021, that Monday is next Monday, October 4th, as the U.S. Supreme Court begins its annual term. It appears the months ahead could well be among the most controversial and historic in the court's history. To bring us his insights and wisdom about what lies ahead, we're pleased to again welcome to Inside Politics Ken Jost. He's one of the country's leading analysts of the High Court, and he got his start in journalism here in Nashville. Ken, thank you for joining us. It's always great to have you on the program.
Good to be with you, Pat.
Set the scene for us. This is going to be the first full term a conservative 6-3 majority is going to be on the court. They'll begin to exert their influence and power, particularly in two hot-button areas before the justices. They regard abortion and gun rights.
Well, that's right. 1 year ago, the court was waiting for Justice Barrett to be confirmed and then to join. So Justice Barrett missed the first month last year, but and what will happen on Monday is that the justices will be on the bench themselves for the first time in more than a year. All last year, they heard oral arguments by telephone. You know, they listened on the telephone at their homes, and lawyers argued over the telephone from their homes or offices. And so now the court has decided that the pandemic has eased enough and the justices have all been vaccinated. And all of the justices tested negative except for Justice Kavanaugh. We learned just this morning that Justice Kavanaugh tested positive. He has no symptoms, and he was vaccinated, and all of his family are vaccinated. And now the question rises now whether Justice Kavanaugh will be on the bench on Monday, along with the other 8, and I guess we'll wait until Monday to find out the answer to that question. But in any event, the court is somewhat back to normal, except there still will be limits on the audience in the courtroom.
When the court does get back into hearing cases, one of the ones they're going to hear is from Mississippi. It again seeks to challenge the Roe v. Wade standard or precedent that the court set almost 50 years ago about abortion rights. The Mississippi case sets standards that really make it more difficult to get an abortion. They set a prohibition on when abortions can occur that's much shorter than much longer. In terms of pregnancy, it may be so early that a lot of women may not know they're pregnant. Is there something about the Mississippi law that is strong enough or different enough that it might give the conservative majority a reason to overturn or to modify Roe v. Wade?
Well, remember that President Trump promised to appoint justices who would vote to overrule Roe v. Wade if given the opportunity. So at this point, there's at least a 50-50 chance that this court will overrule Roe v. Wade to some extent by the end of the term. And Tennessee has an important stake in that. Tennessee passed a law 2 years ago that would ban abortion completely in the state if Roe v. Wade were to be overruled. There are 10 other states besides Tennessee that have passed so-called trigger laws that would ban abortion if the court were to overrule Roe v. Wade. And we won't know the answer to that question until the end of June.
There's also another abortion-related law that has been before the courts, at least on a preliminary ruling from Texas. It also sets an even stricter standard on when abortions can occur. It used to be 24 months under Roe v. Wade, which was when they thought a fetus might be viable. The Texas law also allows anybody, private citizens, to enter into lawsuits to basically bring into court people that have any involvement at all with an abortion, and they could be fines brought against them. Given the high stakes standards, the court ruled on this on what's called sort of its emergency or shadow docket. Did the court rule on this because of the merits of the case to allow the law to go into effect, or was this about standing who's bringing the lawsuit?
This was a procedure. Was a procedural decision that the court, dividing 5-4, said, "Oh, we don't have a handle to rule on this case at this moment because the state of Texas says we're not enforcing this. It's only up to the people of Texas to enforce it." And so ordinarily, if someone challenges a state law, the defendant is, the executive branch official is named as the defendant. For instance, in Mississippi, the Mississippi groups that are challenging the Mississippi law sued the state health director, Mr. Dobbs. And so that case is known as Dobbs versus Jackson Women's Health Organization. The Jackson Women's Health Organization is, in fact, the only abortion clinic in the entire state of Mississippi.
Now,
so that case is going to be argued on December 1, and it will be a showdown of showdowns.
Now, as I understand it, what you were talking about earlier about private action in this, the 14th Amendment is what the courts used in the past to set up the abortion rights. This is about private action, not state actions. Some think the Texas law, enforced through lawsuit by private individuals, is an attempt to make an end run around the Constitution. And there were similar efforts in Texas back in the 1950s to turn over the operation of elections to private companies in order to make it harder for blacks to vote. Is this deja vu all over again, just on a different topic?
On a different topic, and indeed, Texas used to have an all-white Democratic primary, and when the Supreme Court said you can't do that, Texas came up with the idea of, well, why don't we just allow private parties to run the election? And that didn't work. But this effort to get around federal courts is more elaborate, and at the least ever since September 1 now, ever since September 1, the law in Texas has prohibited abortions after 6th week of pregnancy, and indeed, it's possible for a woman to be 6 weeks pregnant and not know for sure. And the Texas bill is called the Heartbeat Act, and it says so: no abortions after a heartbeat is detected, and the rough time frame is 6 weeks.
Ken Jost is our guest on Inside Politics. He's one of the leading analysts on the U.S. Supreme Court. The court begins its new term on Monday. Back to continue our conversation with Ken after this break.